In recent months, reports have begun circulating within communities of former Jehovah's Witnesses, researchers, and legal observers suggesting that something unusual may be happening with the organizational structure of individual congregations in the United States. According to these reports, some congregations are allegedly being registered as independent religious corporations, separate legal entities distinct from the traditional centralized watchtower corporate structure that has existed for over a century. These claims have generated considerable discussion, but they come with a significant challenge. There has been no official statement from the Watchtower organization acknowledging any such restructuring. No letters have been read to congregations. No announcements have appeared in official publications. The organization has remained entirely silent on the matter, leaving researchers to piece together information from unofficial sources and second-hand reports. What makes this situation particularly difficult to investigate is the fragmentary nature of the available information. Some individuals claim to have found corporate registration documents in state business registries showing congregations listed as independent corporations. Others report that local elders have been designated as corporate directors on these alleged filings. The pattern, if it exists, appears to span multiple states including New York, California, and North Carolina. However, we must be clear about what can and cannot be verified at this stage. Without direct access to confirmed official documents, without statements from the organization itself, and without comprehensive data showing the scope of any restructuring, much of what is being discussed remains in the category of reported claims rather than established facts. This investigation will examine what is being alleged, why such allegations have gained traction, what the potential implications would be if true, and what questions need to be answered. The central question is straightforward. Are individual Jehovah's Witness congregations being converted into independent legal corporations? And if so, why is this happening without public explanation? The corporate past of the organization. To understand why reports of congregation incorporation have generated such intense interest, we need to establish what the legal structure of the Jehovah's Witness organization has traditionally been. The Watchtower organization has always operated through formal corporate entities, a fact that is well documented and publicly acknowledged. Since 1884, when Charles Taze Russell established the Watchtower Bible and Tract Society of Pennsylvania, the organization has functioned through legal corporations. Over the decades, additional corporate entities were created to handle different aspects of the organization's operations. The Watchtower Bible and Tract Society of New York became a primary operating corporation. The Christian Congregation of Jehovah's Witnesses was later formed to manage congregation-related matters. Various other auxiliary corporations were established to handle real estate holdings, publishing operations, and administrative functions. This multi-tiered corporate structure has always been centralized, with ultimate authority resting in the governing body. Doctrinal decisions, policy changes, and administrative directives flow from this central authority down through the organizational hierarchy. The system is deliberately hierarchical, with power concentrated at the top and strict adherence to organizational direction required at all levels. Individual congregations, however, have historically operated without independent corporate status. They existed as religious gatherings under the umbrella of the larger Watchtower corporate structure. While some congregations might have had associated corporations formed specifically to hold Kingdom Hall property, the congregations themselves were not separate legal entities. They functioned as informal groups of believers meeting under the supervision of appointed elders who ultimately answered to the central organization. This established pattern is what makes the current reports noteworthy. If congregations are indeed being registered as independent corporations, it would represent a departure from more than a century of organizational practice. The question is whether such a change is actually occurring on any significant scale. The claims that have sparked this investigation center on alleged corporate registration documents. According to various reports circulating in ex-Jehovah's Witness communities and researcher networks, individuals searching state business registries have purportedly found evidence of congregations being registered as separate religious corporations. These alleged findings describe a consistent pattern. The reported documents supposedly show individual congregations registered with their own federal tax identification numbers, their own articles of incorporation filed with state governments, their own registered agents, and their own boards of directors. In multiple cases, the directors allegedly listed on these filings are local congregation elders rather than members of the governing body or officials from the central organization. The geographic distribution of these reports is notable. Claims have emerged from multiple states scattered across different regions of the United States. This breadth suggests that if the reports are accurate, The phenomenon is not limited to a single locality or handled by a single regional legal office making isolated decisions. However, several important caveats must be acknowledged. First, the individuals making these claims are generally former members or researchers who are critical of the Watchtower organization, which raises questions about potential confirmation bias or motivated interpretation of ambiguous information. Second, many of these reports come through informal channels, social media posts, or discussion forums rather than through verified journalistic investigation. Third, the organization's complete silence on the matter means there is no way to verify whether these documents represent a systematic policy change or isolated cases that might have specific local explanations. What we can say is that these reports exist, they are being discussed widely, and they follow a consistent pattern across multiple sources. What we cannot say with certainty is whether they accurately represent a widespread organizational restructuring or whether there might be alternative explanations for whatever documentation may have been found. The absence of official acknowledgement creates a vacuum that speculation naturally fills. Without transparency from the organization itself, observers are left to draw conclusions from incomplete information, which is precisely why this situation demands careful, fact-based investigation. One reason these reports have gained traction is the legal environment in which the Watchtower organization currently operates. Over the past decade, the organization has faced significant litigation related to child sexual abuse allegations, particularly in the United States and other Western countries. Numerous lawsuits have been filed by individuals who allege they were abused as children within Jehovah's Witness congregations, and that organizational policies contributed to an environment where abuse could occur and be concealed. These cases have accused the organization of maintaining internal procedures that allegedly discouraged reporting abuse to secular authorities and prioritized organizational reputation over victim protection. Several U.S. states have enacted look-back window legislation, temporarily suspending statutes of limitations for child sexual abuse cases and allowing victims to file lawsuits for abuse that occurred decades earlier. This has resulted in a substantial increase in legal actions against the organization. Some of these lawsuits have attempted to hold the Central Watchtower organization directly liable, arguing that because the organization maintains strict hierarchical control, issues detailed policy manuals to elders, and requires adherence to centralized procedures, it bears responsibility when those procedures allegedly contribute to harm at the local level. This legal context provides a framework for understanding why observers have interpreted reports of congregation incorporation as potentially significant. Legal experts familiar with organizational liability strategies note that when large institutions face extensive litigation with substantial financial exposure, they sometimes restructure their legal frameworks to limit liability. One common approach is to decentralize, creating multiple smaller independent entities rather than maintaining a single unified corporate structure. The theory, from a legal liability perspective, is that if each congregation becomes its own independent corporation, legal claims against one congregation would face additional barriers in reaching the assets or establishing the liability of other congregations or the parent organization. This concept, known as limited liability or corporate veil protection, is a standard practice in corporate law. It's important to emphasize that we have no official confirmation that liability limitation is the motivation behind any congregation incorporation that may be occurring. The organization has not stated this, and we cannot assume motivations without evidence. However, the timing of these reports, coinciding with increased legal pressure, has led some observers to propose this as a plausible explanation. If the reports of congregation incorporation are accurate, the implications would vary significantly depending on one's position within the organization. For average members attending meetings and participating in congregation activities, such a change would likely be invisible in practical terms. The worship services would continue unchanged. The door-to-door ministry would proceed as before. The doctrinal teachings would remain the same. From the perspective of daily religious practice, members might never notice any difference. The organizational authority structure would presumably remain intact as well. The governing body would continue to set policies and issue directives. Circuit overseers would continue to supervise congregations. Elders would continue to receive procedural manuals and follow organizational guidelines. The centralized control that has always characterized the Watchtower organization would likely persist regardless of changes to underlying legal structures. However, for elders who might be designated as directors of newly formed congregation corporations, the situation could be fundamentally different, assuming they understand what that designation means. When someone serves as a director of a corporation, they assume legal responsibilities that extend beyond religious duties. Corporate directors have fiduciary obligations. They can be held accountable for decisions made in their capacity as directors. In certain circumstances, they can be sued individually. The critical unknown is whether elders who may have been designated as corporate directors have been adequately informed about the legal implications of that role. Have they received training on corporate governance? Do they understand their potential personal liability? Have they been advised to consult legal counsel about accepting such positions? Based on the silence surrounding this entire matter, it seems unlikely that extensive education about corporate directorship has been provided. This raises a significant ethical question, if the reports are true. If congregations are being incorporated, if elders are being designated as corporate directors, and if this is being done without proper disclosure of the legal implications to those individuals, it would represent a concerning lack of transparency. Even more troubling would be a scenario where organizational authority remains centralized at the top, with the governing body continuing to set all policies through official channels, while legal liability is shifted to local elders who are simply following directives from above. Again, we must emphasize that without official documentation or statements from the organization, we cannot confirm this is actually happening. But if it is, these would be the logical concerns that emerge from such a structure. At this stage of investigation, intellectual honesty requires clearly distinguishing between what can be stated with confidence and what remains uncertain or unverified. On one side of that line, we have confirmed facts. The Watchtower organization does face significant ongoing litigation related to abuse allegations. Legal strategies involving corporate restructuring to limit liability are well-documented practices in organizational law. Reports of congregation incorporation are circulating widely enough to have generated substantial discussion within ex-member and researcher communities. On the other side of that line are the claims that cannot yet be independently verified. We do not have confirmed, authenticated documentation proving that a systematic program of congregation incorporation is underway across the United States. We do not have official statements from the Watchtower organization acknowledging such a restructuring or explaining its purpose. We do not have testimony from current elders confirming they have been designated as corporate directors without adequate disclosure. We do not have comprehensive data showing the scope of any incorporation that may be occurring. What we have instead is a pattern of reports, allegedly supported by documents some individuals claim to have found, describing a consistent phenomenon across multiple geographic areas. The pattern is striking enough to warrant serious investigation, but the evidence base remains incomplete. The organization's silence on the matter is itself noteworthy. If these reports were entirely baseless, if they represented fundamental misunderstandings of routine administrative procedures, a simple clarifying statement could resolve the confusion. The absence of such clarification leaves room for continued speculation and concern. Moving forward, what this situation requires is systematic, verifiable documentation. Researchers who have access to state business registries should conduct methodical searches and compile their findings in a format that can be independently verified. Journalists should attempt to obtain official statements from Watchtower representatives about whether congregation incorporation is occurring and, if so, what the purpose is. Elders who may have been designated as corporate directors should be informed of their legal status and encouraged to seek independent legal counsel. Until such documentation emerges, we are left with concerning reports that follow a logical pattern given the current legal environment, but which lack the definitive proof necessary for conclusive statements. What appears to be emerging from these reports, at least within the United States, is the possibility of a significant legal reorganization being conducted without public acknowledgement. If accurate, congregations are being transformed into independent corporate entities, elders are being designated as corporate directors, and legal structures are being altered in ways that could have substantial implications for how liability is distributed within the organization. The transformation, if it is occurring, is being conducted with remarkable opacity. No official announcements. No explanations to members. No disclosure to elders who may be taking on new legal responsibilities. Just documents appearing in state registries, discovered by individuals who know where to look and what to search for. This pattern, if confirmed, would be consistent with how many large institutions handle significant structural changes. Legal departments make decisions based on risk management considerations. Corporate attorneys file necessary documents. Structures are quietly modified. And the people who volunteer their time, donate their resources, and place their trust in the institution are kept in the dark about what is being done. But the truth, whatever it is, deserves to be known. If congregations are being incorporated, members and especially elders have a right to understand why. They have a right to know what legal implications this has. They have a right to make informed decisions about their involvement with full knowledge of how the organizational structure is changing. If you are an active Jehovah's Witness, particularly someone serving as an elder, you should determine whether your congregation has been incorporated. You should know whether your name appears on any corporate registration documents. You should understand what responsibilities and risks that might entail. These are not minor administrative details. If true, they represent fundamental changes to your legal relationship with the organization. If you are a researcher or former member, continued investigation is warranted. State business registries are public records, accessible to anyone willing to search them. Documentation should be compiled, verified, and made available for independent assessment. The pattern needs to be mapped comprehensively so we can move from fragmentary reports to verified facts. For journalists, this story represents an important test of institutional transparency and accountability. Organizations that claim moral authority and demand absolute trust from their members have a corresponding obligation to operate with honesty and openness. When significant structural changes occur in silence, when legal responsibilities are redistributed without disclosure, those are stories that deserve professional investigation. The reports exist. The pattern is consistent. The timing is suspicious. The silence is revealing. But definitive answers remain elusive. What we need now is not more speculation but more facts. More documentation. More verification. More transparency. If this restructuring is occurring as reported, it represents one of the most significant organizational changes in modern Watchtower history, conducted entirely outside public view. That alone demands explanation. The truth is there, waiting in public records, in corporate filings, in documents that exist whether or not the organization acknowledges them. The question is whether enough people will look, document what they find, and demand the transparency that members and the public deserve.